dakiika 3 nja kuba nvuddeyo.
Yes, madam.
Is brought under Article 23, Clause 6A and C, and Article 28, Article 3, Sub-Article Clause 3A of the Constitution, Section 14 of the Trial and Indictments Act, Rules 2 and 11, Sub-Rule 2 of the Constitution, bail guidelines for courts of judicature, practice direction is 2022 for orders that the applicants be released on bail pending the hearing and disposal of their trial. The grounds for the application are briefly that the first and second applicants are charged with destroying evidence under Section 102 of the Penal Code Act, which is a bailable offense. To that, the third and fourth applicants are charged with the offense of being an accessory after the fact of murder, according to Section 93, subsection 1 of the Penal Code Act, which is a bailable offense. The applicants are presumed innocent until proven guilty. These are the grounds of the application. Until proven guilty, and that they have substantial sureties to guarantee their attendance in the court. The applicants are breadwinners of their respective families, and that they have fixed places of abode within the jurisdiction of this court, and they shall not abscond if granted bail. That the applicants also stated that they have substantial sureties who undertake to ensure that they attend the court when required. More specifically, the first applicant states that she suffers from fluctuating severe hypertension, heart diseases, chronic clinical gastritis, which requires regular access to specialized medical treatment and monitoring not accessible in the women's prison. The second applicant also states that she is a nursing mother and suffers from postpartum complication is detailed in the medical report attached to the application. She contends that her condition demonstrates special circumstances for court's consideration. I have also considered the grounds raised by the third and fourth applicants, which are contained in their respective affidavits in support of the application, which I shall also consider in determining this application. The respondent opposed the application through the affidavit shown by Anna Chiza, Chief State Attorney, and the number 30844, Detective Sergeant Betese David. They contended that the applicants are a flight risk, which with the possibility of abscondment. They also contended that the fourth applicant has no known permanent place of abode of his own. The respondents also further contend that the particulars of the sureties presented by the third applicant indicate that they do not have a permanent fixed place of abode. The respondent further contended that with no evidence of a fixed place of abode, the accused person is likely to abscond. It was further contended by the respondent that the offences which the applicants are charged with are connected to a charge of murder which is grave, and thus they are likely to abscond or frustrate the hearing of the case. The respondent further also stated that the second applicant neglected and denied court summonses and was only compelled to appear in court upon issuance of a warrant of arrest, and that none of the applicants have presented any exceptional circumstances to warrant their release on bail by the High Court. It was further argued by the respondent that the matter in issue is of great public interest and there is a real possibility of the accused person is interfering with witnesses. Further, that the investigation in this case are complete and all the applicants have been committed for trial in the High Court, and that it will serve the interest of justice if the case is instead fixed for hearing as opposed to releasing the applicants on bail. The applicants made a rejoinder to the points raised by the prosecution, which I have considered, though not reproduce them here. At the hearing of the application, the applicants were represented by Mr. Jet Mweba Zelson Karuhanga, Bruce Chunguzi, and Senior Counsel Kabega. The prosecution was represented by Jonathan Mwaganya and Miss Samari Wakori. Each of the parties filed their written submissions and made or highlights, which I have also considered. I will deal with the preliminary objection raised by the state with respect of the admissibility of the affidavit in rejoinder filed by counsel for the applicants, specifically Mr. Bruce Msinguzi. It is the contention of the respondent that the affidavit in rejoinder cannot be relied on for being argumentative, prolix, and in non-compliance with Order 19 of the Civil Procedure Rules, which provides that an affidavit shall be confined to such facts as the deponent is able on his own to prove, especially in interlocutory applications, except in interlocutory applications on which statements of his belief may be admitted, provided that the grounds thereof are stated. Counsel for the respondent specifically referred to paragraph 7, 8, and 9 of the affidavit in rejoinder and urged that the amount to hearsay as counsel for the applicant does not state the source of his information. I consider the relevant paragraphs of that affidavit in rejoinder. In paragraph 7, counsel for the applicant avers that the first and second applicant presented medical reports to demonstrate exceptional circumstances. The paragraph is confined to the presentation of exceptional circumstances already stated in the application, with which the applicant and our counsel are aware of. It is within the knowledge of the counsel for the applicant. It is within the knowledge of counsel that the applicant obtained medical reports to prove exceptional circumstances, and it does not require him to disclose his source of information. The same applies to the other paragraphs of the affidavit referred to by the respondent. The averments made by counsel for the applicant are relevant for purposes of pleading and are sufficient to inform court of what the applicants have already pleaded in the affidavits in support of the application. In these circumstances, I find that the affidavit does not offend Order 19, the civil procedure rules. I now turn to the merits of the application. Article 23, Sub-Article 6 of the Constitution invests this court with the power to grant or decline a bail application made before it. The same provision requires that the grant of bail should be on such terms as the court considers reasonable. Article 23, Sub-Article 6A does not give guidance on how courts are to determine the reasonableness. It has been held that the reasonableness test is the need for the court to weigh all relevant factors before granting the bail to an accused person. This is the case of Foundation for Human Rights Initiative versus Attorney General. The relevant factors, in my considered view, are the likelihood of the accused attending his or her trial, the risk that if released on bail, an accused person will interfere with the witnesses, or the likelihood of committing another offense, the seriousness of the charge, and the need to protect the society against lawlessness. The court will also consider whether it is in the interest of justice to grant the application. The burden to demonstrate how prejudicial it is to the interest of justice that an accused must not be granted bail rests with the state. The first and second applicant here referred to as Kakwanzi Patricia and Nkwanzi Martha Katanga are charged with destroying evidence contrary to Section 102 of the Penal Code Act, while the third and fourth applicants herein referred to as Otai Charles and Amanyire George are charged with the offense of being an accessory after the fact of murder under Section 393(1) of the Penal Code Act. The first applicant contended that she suffers from fluctuating severe hypertension, heart disease, chronic clinical gastritis, which requires regular access to specialized medical attention and monitoring not accessible in the women's prison. She presented a medical report from the Uganda Prisons Medical Superintendent, marked as Annexure B3. It is noted that the health condition is referred to therein are risk in prison conditions. Under Rule 14.2a of the bail guidelines, exceptional circumstances include grave illness certified by a medical officer of prison. I find that the medical report presented by the first applicant demonstrates exceptional circumstances for court's consideration. The second applicant contended that she is a nursing mother and suffers from postpartum complications. She presented evidence from Roswell Women's and Children's Hospital. In the report, it is stated that she has elevated blood pressure and suffers from postpartum pre-eclampsia. There is no doubt that postpartum complications require frequent attention. In Kagenda, Stephen, and others versus Uganda, this court noted that a newly born child and a mother may require care and attention which may not be provided for in prison facilities given the circumstances where the mother is incarcerated and the child is not with her. I find that her condition constitutes an exceptional ground for court's consideration. The exceptional circumstances referred to in Rule 14.2 are not exhaustive, and the court may infer other exceptional circumstances on a case-by-case basis, depending on the circumstances of each case. The respondent argued that the applicants are jointly charged on a charge sheet with a murder count. It was their contention that the charges are grave and that the applicants may abscond if released on bail. There is no doubt that the There is no doubt that the seriousness of the offense has a clear bearing on the court when considering a bail application. Seriousness of the charge and the possible outcome of a conviction and the temptation to jump bail if released or interfere with the witness should be a key consideration. The respondent clearly informed the court that the applicants have already been committed for trial in the High Court and are only awaiting hearing of the matter. So the possibility of interfering with the witness at this stage may be speculative, as the applicants still enjoy the presumption of innocence. The question of the possibility of interfering with witnesses requires proof and not mere speculation. I'll now deal with the sureties presented by the applicants. In the considering the suitability of a surety, the court shall take into account the following factors: the age of the surety, work and residence, address of the surety, character and antecedents of the surety, relationship to the accused person, and any other factor as the court may deem fit. See Rule 15 of the Constitutional Bail Guidelines for Courts of Judicature Practice Directions of 2022. The first applicant presented her husband, Mwine Mukuru, her mother-in-law, Zache Marian Samanyanga, and her father-in-law, Kamujisha Herbert. They appeared able to make good of the recognition set by this court if the need arose. I therefore accept all the sureties presented by the first applicant. Further, I am satisfied that the relations between the applicant and their surety is such as would ensure the first applicant's appearance for trial. The second applicant presented her husband, Kivura Christian, her auntie Harriet Mchunguzi, and Bashasha Willis, a close family friend. They were all known to the second applicant, and with their close ties, they appeared substantial to guarantee the second applicant's attendance in the court. It is worth noting that the respondent did not have any specific objection to the sureties presented by the first and second applicant. The third applicant presented his brother, Opio Godfrey, his sister, Alamo Christine, his wife, Nakasuja Shamim, and his mother-in-law, Kaya Hasfa Vokenya. The respondent objected to the fourth surety of the third applicant on the ground that she did not have her original identification. They also argued that the second surety did not know where she works and invited the court to consider her demeanor. With regard to the first surety, the respondent argued that the surety, being a serving UPD officer, did not have clearance from his superiors to stand surety and did not avoid any document such as his warrant movement card. The prosecution also argued that the fact that soldiers are deployed outside the boundaries of Uganda without prior notice makes it difficult to access him. With regard to the fourth surety of the third applicant, she presented a letter from NIRA with a verifiable NIN number which was not disputed by the respondent. The failure to avoid her original identification is explainable, and this court takes note of that fact, of the fact that the surety says that her original is lost and has undertaken a legal process to replace it. The documented proof of the letter from NIRA confirming her particulars to me is sufficient. As for the second surety for the third applicant, I have considered her relationship with the third applicant and not her demeanor, as demeanor can be misleading given the tense atmosphere that may be associated with the court hearing, of which the surety may not be accustomed. Demeanor alone cannot be enough to impugn the suitability of a surety. All factors with regard to suitability of a surety must be considered as a whole. As for the UPDF officer, There is no specific law that bars a UPD officer from standing as a surety for an accused person. There is also no specific law that requires a UPD officer to first seek clearance before he or she stands surety for an accused person. The most important consideration should be whether they can prevail over, control, and where necessary, compel the accused person to abide by the terms and conditions of bail. This therefore calls for persons of proven influence or authority of the accused person over the accused person, and no better person than the soldier who is a brother to the third applicant is qualified for that. Requiring the surety to first seek clearance from his superiors in order to stand surety for an accused person in court may in one way or the other impact on the accused's right to apply for bail provided for in Article 23(6)(a) of the Constitution. Therefore, upon the accused person applying for bail to choose which sureties to present to court for its consideration. Whether they are substantial or not is another matter that the court has to consider. There was no requirement for the first surety of the third applicant to seek clearance from his superiors before he agreed to stand surety for the third applicant. With respect to the fourth applicant, the respondent argued that there is no proof that he has a fixed place of abode, that the LC1 letter presented to court recommends him as a surety for someone and not proof of his residence. In response, counsel for the fourth applicant argued that the court must consider the substance of the letter, which states that the fourth applicant is a resident of Mbuya 2 parish and it should be taken by court as his place of in the LC letter is not fatal, as the letter states that the fourth applicant is a resident of Mbuya 2 parish, and the same is contained in his affidavit in support. The sureties presented by the fourth applicant were also known to him and appear to have authority over the applicant. When interviewed by the respondent, they had knowledge of his antecedents. They were asked the name of the applicant, which was known to them. When asked what was Amanyire's mother's name, they all said the mother's name is Ada. Sharon said that the mother's name is also Ada. The one who did not know the parent's name is a friend. When asked where does Ada reside, indeed all of them answered that it was in Mbuya, with one of them on top of Mbuya giving details of the village. I do not find them as professional sureties as suggested by the respondent. Counsel for the applicants also stated that the applicants qualify for release on mandatory bail under Article 23(6)(a) of the Constitution, which provides that where an offense is triable by the High Court as well as by a subordinate court, if a person has been remanded in custody in respect of that offense for 60 days and trial has not commenced, that person shall be released on bail on such conditions as the court considers reasonable. It follows therefore that the offenses with which the applicants are charged are bailable are trial by High Court and the subordinate courts. They have been on remand since 21st of November 2023, save for the second applicant who has been on remand since 10th of January 2024. For the first, second, and fourth applicants, more than 60 days have elapsed and their trial has not commenced. In such a case, the court is obliged to release the accused person is on bail on such terms as it considers reasonable, while I've already agreed with the second applicant on her condition. Lastly, the prosecution prayed for punitive terms in case the applicants are released on bail. Bail terms should not constitute punishment, and the fact that the accused persons are not convicts should be reflected in their treatment and management. I am satisfied that the applicants have made out their case for the grant of bail. I shall accordingly grant them bail on the following terms. Each of them shall make cash deposit of 2 million shillings, and each of their sureties will execute a bond of 20 million, non-cash bond of 20 million. Each of the accused applicants shall not travel outside of the country without the express permission of court, and if any of them is holding an invalid passport, then they shall be placed in the custody of the court. Each applicant shall report to the Deputy Registrar of the Criminal Division every first Monday of each month, beginning on the 4th day of March 2024. I so order.
To change the statements which he made to the police. My Lord, we find this most unconventional and totally unacceptable and much of that. Agents of the state. Sorry, my Lord. Okay. Right. I'm saying, my Lord, that we have a housekeeping matter which we want to bring to the attention of the court. My Lord, that is that the state has on 3 different occasions approached our client in Chigo prison talked to him in an attempt to make him retract, change or vary the statements which he made at police. My Lord, this is an issue which has left our client uncomfortable for the number of days he has been in Chigo prison.
Uncomfortable?
Yes, very uncomfortable. But why would some officers from the office of the DPP and the police be approaching him? The state informed the court that investigations are over. They were committed for trial and is now in the hands of the court, not anymore in the hands of police or in the hands of DPP. My Lord, our client is here, and if the court wishes to find out more from him, you can actually do so. So we thought, my Lord, that we should bring this matter to court, that these attempts, that, right. Yeah. That's what we wanted to bring to the attention of the court, my Lord.
We've not done such a thing.
Okay, now, see, in prison is there. Is that the prison is yours?
Exactly.
So if there is any problem there, I can always raise it.
Yeah.
The prison is authority.
Exactly.
I don't want to put it to start.
Yeah. Like
Yeah.
managing now.
I don't see whatever. But if it's that comfortable, can raise it. So then,
It's uncomfortable because of the approaches, my Lord. It's not a matter.
okay, please, let's see.
What is happening?
Okay, the DPP is in charge
Stop it.
of their case.
Yes.
Please.
This bail application is the most urgent bail application in the history of Uganda. It has been adjourned 15 times, so we are happy that the accused persons finally have gotten justice. They can get their bail, and we are happy with the decision of the judge. Secondly, we are so dismayed by the practice that the DPP is engaged in. The DPP has charged people. By the time you charge people, it means you have enough evidence. You can't charge somebody, commit them to the High Court for trial, and then begin to change him from Ruzira to Chigo and visit him 3 times and urge him to change his statement. This is a poor Shamba boy who doesn't understand English, who they are coercing every time to change his statements and accuse his co-accused. So we are dismayed. Those are the 2 things I needed. We are happy that they have been released on bail. But we can't believe what is happening to the profession, especially the DPP's office, by our colleagues at the DPP's office, led by Muwaganya himself, doing exactly what is despicable. You can't visit him. I can name for you everybody, but that team is led by Mr. Muwaganya. We are ready. The hearing should start tomorrow. That's actually why they want people to change their statements, because they have no evidence against them. We are ready like tomorrow. They let them start the hearing like tomorrow. We're going to apply. We wanted this one out of the way. We are going to apply before close of business tomorrow. That I can tell you for free. They are fine. We will comply with them. Because you remember the DPP had prayed for 100 million. Where does a Shamba boy get 100 million? Where does a young woman like Martha, who is just married the other day, who is 28 years, get 100 million? Land titles. Does it mean that a poor person who has no land title, 100 million, doesn't get bail? So the DPP has a problem. Somebody needs to check that place. I hope the DPP understands what she's presiding over. Thank you.